All righty, welcome everybody. We'll give it a moment before we dive too deeply, but good to see everyone in the chat. Per usual, feel free to use the Q&A for specific questions, and the chat is open to communicate between attendees as well as with us. Chat tends to be a little more active, so feel free to use either or. There is the opportunity to turn on closed captioning. If you go into, for me, if I'm looking on my computer, I have to see there's the 3 dots above the word more. I click on more, then there's pause recording, stop recording. This is for me, but then there's captions, and you can turn captions on if that's something to support you when it comes to just general interpretations of what we're saying and or listening and or experiencing needs.
Also important,
good,
because if nobody saw, there was yet another lawsuit filed against Housing Works in the card program because their website was not ADA compliant for the blind. So kind of apropos to mention that, Zach.
Yeah, absolutely. Well, welcome everyone. We have a really interesting topic today. We're going to be diving into part 124 of the proposed regulations for adult use cannabis in New York State, and that will be covering the general business requirements and prohibitions. We've been meeting Tuesday, Thursdays for the past couple months, and hosting these conversations from noon until 1:15, and we're anticipating being able to finish this read through within the next few workshops. This read through is supported and brought to you by Cannabis Association of New York, CANY, as well as the Rochester Public Library, built on the belief that access to information is really a building block, a foundational component of an equitable and accessible industry. So we're here to really create this kind of open classroom space to digest these regs. The next layer of that too is we're in a comment period where the current regs we're reading through are proposed, and within the proposed regs, there's this a 60-day comment period that individuals such as ourselves or organizations can develop their own perspective and comments pertaining to the proposed regs. And it's a really great opportunity to kind of look for discrepancies or places where we're confused and needs more explanation, and or have the opportunity to kind of critique and then counter propose regulatory structure. So as we're reading through these regs, we kind of put on a bunch of different lenses: critical analysis, general requests for places where we can request more clarification to better understand what we can and cannot do or what's proposed. And then even in some cases where we may have an alternative idea that might be better for the industry as a whole, as we perceive it. So yeah, that's the lenses that we're working with as we unpack and digest. And yeah, happy to be co-presenting today alongside my colleague, Jason Klimek. I'll let Jason introduce himself and then we'll dive in from there.
Thanks, Zach. I'm Jason Klimek. I am the chair of the CANY Policy Association, as well as the chair of the tax committee for the New York State Bar's Cannabis Law section, and the leader of the cannabis practice for Barclay Damon.
Great. And my name is Zach Sarkis. I'm chair of the education committee for CANY, as well as work with the Rochester Public Library to help build out cannabis-related programming. Also been working in the world of cultivation in New York State since 2018. And I'm a small business owner that is interested in participating in this space. And so I kind of bring the supply chain hands-on perspective to the interpretation of the regs. And yeah, from there, again, we're picking up on page, what was it, 197, part 124, general business requirements and prohibitions. And again, folks who are just tuning in, feel free to jump in the chat, as well as the Q&A for asking questions and engaging. This is definitely going to be an interesting section that really underlines what we're able to do or not do in these proposed regs. It's also fun to kind of say, feel free to check in where you're listening from. Often we have folks from all over the state, and it's fun to feel connected that way. So feel free to drop your name and location in the chat if you feel called. All right, so I will share my screen and we'll go from there.
I would also note too that like this section in particular, this is kind of the foundation for the two-tier system. This whole thing is basically why it exists, to avoid undue influence. But what we're going to see is a lot of times it might be a little bit kind of amorphous as to what undue influence actually is. Some things will be very blatant. Other things are, you know, a judgment call, and we're going to have to kind of see through, I think, further guidance and potentially, you know, administrative court decisions as to what undue influence actually is and isn't. Unfortunately, because there's no bright line rule that this is undue and this is not, it's going to kind of be a learning experience, I think.
Jason, would you like to lead?
Sure. All right. So, undue influence and incentives. No person shall enter into any agreement which, if entered into, may cause undue influence over a licensee as set forth in this part. This rule shall not be construed as prohibiting the placing and accepting of orders for purchase and delivery of cannabis or cannabis products that are made in accordance with usual and common business practices and that are otherwise in compliance with this chapter. No distributor, microbusiness, cooperative, ROD or ROND shall advance, and no licensee authorized for retail sale of cannabis or cannabis products to consumers shall receive money or a benefit equivalent to the value of money under any agreement or by any means of any other business practice or arrangement, such as gifts, discounts, except as otherwise permitted by this section, customer loyalty programs, loans of money, premiums, rebates, royalties, free cannabis product of any kind except as otherwise permitted by the section, preferential shelf space or displays, and treats or services of any nature whatsoever, except a discount not in excess of 1% for payment on or before 10 days from the date of shipment of such cannabis, such services as authorized in this section or which may be authorized by a license issued pursuant to the cannabis law. So, I mean, that's really, you know, trying to not tip it in favor of bigger players who maybe could give much more beneficial terms and things or benefits to retailers, whereas the smaller players couldn't necessarily do that. So it's trying to level the playing field. But remember, that's not an exhaustive list. It's those things and whatever else is undue influence as determined by OCM.
And it's really interesting, even just like preferential shelf space or displays, like royalty, like there's all sorts of little things in there that, you know, you may not think of necessarily bad, but thinking about the disproportionate impact of, like, you know, folks who have a lot of resources and how they can leverage that to in turn kind of claim power over the market is kind of the lens I think this has been developed through. It's interesting, a discount not in excess of 1% for payment on or before 10 days of the shipment. So essentially they're saying, you know, if someone's paying their bill fast and upfront, basically, there's the opportunity to give a 1% discount on that payment. But other than that, no discounts.
Yep. All right. Licensees are prohibited from requiring the purchase of other products or services by other licensees as a condition of a transaction of cannabis or cannabis products. Products and services include, but are not limited to, other cannabis or cannabis products or brands, merchandise, paraphernalia, property, software, or applications or services. So really, there's no bundling insofar as if a retailer, for example, wants a popular cannabis brand, in order to move some other product, a distributor couldn't say, you know, yeah, we'll sell you this popular brand, but only if you buy these other products as well that we want to move. Can't do it. And that's probably a good thing, right? You know, everybody should be equal. And if the retailer can only afford to buy the one brand that they want, or they want that one product, then they should be able to do that.
Yeah. I think it's important. Jeff notes in the chat. Good point. This is going back to the shelf space stuff. Good point. Big Canna blocked many small players from shelves in California through shelf space arrangements. And in other states, we've seen like really strong pay to play models where you only get this shelf space if you pay $10,000 a month, like some crazy numbers. That's like kind of extortion. Or again, it's pay to play, and those who got the money can compete, and otherwise folks are kind of pushed to the wayside.
Yeah, absolutely. I mean, it's huge business to do that. Go into a grocery store and shelf placement. A lot of grocery stores will break even just on the money that they get from shelf placement payments. So it's a huge business. So it's good to see that they're prohibiting that, because that does help smaller businesses. All right. A micro business, cooperative, distributor, ROD or ROND may provide free samples of cannabis products to negotiate a sale to a retail dispensary or on-site consumption premises that does not currently carry the brand, type, or form of the cannabis product. Such licensees shall abide by any sample limits set by the office and shall record the amount, transfer, and receipt of each cannabis product sample in the licensee's inventory tracking system in accordance with the requirements set forth in Part 125 of this title. The sample shall be clearly labeled as retailer sample and recorded and tracked on the transport manifest. The receiving licensee shall receive the retail sample in the inventory tracking system prior to sampling the cannabis product. All other packaging and labeling requirements in this chapter shall apply. The retail sample may be usable by the retailer and employees of the retailer, but shall not be sold or given away to cannabis consumers. A distributor, microbusiness, cooperative, ROD, or ROND may provide retailers and their employees with branded promotional items of nominal value. These items can only bear imprinted advertisements of such licensees. The items may not be forwarded on and given to retail customers through purchase or giveaways. What's interesting here is that I'm fairly certain the liquor law prohibits liquor stores from accepting like anything. Like, I don't even think they could get like bottle openers or something like that from distributors or brands. So they're given a little wiggle room there, but it's got to be nominal value. So, you're talking couple of dollars, not anything really more expensive than that.
But even just saying employees branded with promotional items of nominal value. So it's like, can you give a hoodie? I mean, it's relative. Like if I can get a hoodie printed for $10, that's pretty nominal.
Well, and yeah, you're right. Relative is the key term, because if I'm buying $100,000 of cannabis from you, $10 is pretty nominal. But is that nominal for OCM's purposes? I don't know.
Yeah.
As I mentioned, and as we'll see, there's going to be a lot of questions. Licensees are prohibited from giving away or distributing promotional items such as branded or unbranded merchandise to cannabis consumers. For the purpose of this provision, giving away does not include non-infused cannabis product samples of edible or topical products carried by a retailer that are offered to customers inside the licensed premises for sampling purposes only. Any person who, under the definitions of the title, would be considered a true party of interest in an entity and who is permitted for activities which are authorized for a licensee under the cannabis law shall be subject by the true party of interest authorizations and prohibitions for that license type. Terms of sale. Licensees shall sell cannabis and cannabis products or cannabis merchandise or paraphernalia at prices indicative of their true value when sold without any other products, terms, or services. Not discriminate directly or indirectly in price, payment terms, in discounts for time of payment, or in discounts of quantity of merchandise sold. And be prohibited from refusing to sell any brand of cannabis or cannabis product to any person authorized to purchase such brand of cannabis or cannabis product from such licensee as market value or based on price disclosures authorized by the board, provided the purchaser pays cash therefore and accept as herein provided.
I just want to go back up to 2 real quick. So not discriminate directly or indirectly in price, payment terms, in discounts for time of payment, or in discounts on quantity of merchandise sold. So I guess it's twofold. Like, my question is, like, does that mean that you can't provide a discount to merchandise sold in general? Like if you purchase 100 units versus 1,000 units versus 10,000 units? Or is it you just have to be consistent in your discounting?
I think it honestly could be read maybe either way, but the whole discriminate might mean that might mean the latter, that you could give discounts, but you can't say, well, you bought 10,000, I'm going to give it to you for X price, and you bought 10,000, I'm going to give it to you for 2X price. It could mean that, or it could just mean no quantity discounts across the board.
So there's a couple things in the chat. Lee says, what if someone wants to buy your product, but it's outside your distro territory? Do you still have to sell it to them? So meaning like you don't discriminate. Yeah, that's a good question. Especially like for upstate versus downstate, and actually, are you mandated to sell to someone who wants to purchase your product? And it really gets complicated if like most of your distribution is, let's say, Western New York, but there's a downstate dispensary that wants your product. Can you deny? I mean, of course it seems feasible that a business has choice. You can't be forced, but maybe if you have, can you discriminate between saying like one, you'll deliver to one, but you won't to the other? I mean, that's an interesting question.
Yeah, I don't know the answer. I mean, I kind of come down on the side of that has to be allowable insofar as you can say, look, we don't deliver to New York City because we're in Buffalo, and that's just, it doesn't work for our business model. I can't imagine OCM is going to say, sorry, small cultivator who has a distribution license, you have to truck it all the way down to, or Montauk, for example, like you literally have to go to the furthest point in the state. That would seem very, very unfriendly to particularly small licensees, but maybe there's going to be a scale argument that if you only have a distributor license, you're maybe expected to do the entire state because that is your entire business. I don't know. I mean, we're going to have to see. My guess is we'll probably see guidance on this type of stuff.
Yep. Another interesting note, D King says a brewery rep can give glassware and wearables to a retailer, but a distributor cannot. 10 years ago, distributors were allowed to give stuff from breweries, but they're no longer able to. And they mentioned there needs to be parity within the alcohol rules and regs, and they're honest in their opinion, which is interesting. All right, cool.
We on B?
Yep.
Okay. Persons authorized to distribute, including but not limited to distributors, cooperatives, micro businesses, ROND or ROD, shall sell cannabis products to any person authorized to sell cannabis products to consumers, including but not limited to any retail dispensary or on-site consumption licensee willing to pay cash, provided, however, checks shall not be from third parties. Checks drawn on the account of a retailer dispensary shall not be post-dated, and distributors, micro businesses, cooperatives, RODs or RONDs shall not be required except checks drawn on a retail dispensary's account.
I think there's a misspelling. So
yeah,
I would imagine shall not be required
to accept ACC. Yeah. I was having a stroke for a second. Okay. Distributor, micro business, cooperative, ROD, ROND licensees may, but are not required to, allow licensees authorized for retail sales to pay on credit, provided payment terms comply with this part, and retail dispensaries purchasing cannabis products on credit pay their balance due within 30 days. I know this was kind of a point of contention under the card guidance, that card licensees were allowed 90-day payment terms, up to 90-day payment terms. It was at the discretion of the distributor. And there was definitely a concern there that, going a full quarter without payment, a full financial quarter without payment would be very hard for smaller businesses, whereas bigger businesses could maybe float that. And so there might be a preference. This does away with that. But the question is, I think they reiterated in card that it was 90-day payment terms. So, what happens do these override that when these become effective? I would think so, but I don't know. But the 30-day definitely gives more fairness. A 30-day payment term would be pretty common. But 90 days, I mean, I don't know anybody that has standard business terms of 90-day payments. That's a big float.
True.
Distributors, micro businesses, cooperatives, RODs or RONDs shall report retailers who are delinquent in payment for cannabis products to the office and not sell cannabis products on credit to any retailer reported and found by the office to have a delinquent payment due as provided in this section. And note, that is not discretionary, that's required.
Yeah. And so then it's like, well, how are we going to know? And do that? Does OCM notify?
I would imagine OCM is going to put out a list.
Yeah. Yeah. I think that is the case. Let's see if there's a little comment here. Okay, cool. Yeah, Jeff says, lack of timely payments, changing the amount terms, and non-payment with no accountability has been a huge issue for small producers in California. I mean, I've heard rumors of the air quote, the debt bubble that's about to burst in California, and a lot of it is business to business debts, let alone small producers struggling, to pay the fee, tax, etc. So, yeah, that's a brutal reality in other places that we definitely want to avoid. And having accountability is the starting point.
And I mean, good for OCM putting that in there, because it really is a good, it's a kind of stick and carrot approach of, if you comply and you don't, you don't fail to pay people, you could get credit terms if they're offered, but if you don't, it's cash on delivery. All right. Each such distributor, micro business, cooperative, ROD, or ROND is hereby required on or before the respective notification dates as determined by the office for each retail dispensary license to give written notice of default by first-class mail to all such licensees therein who have failed to make payment to them on or before the final payment date for cannabis products sold or delivered to them during a credit period ending on their final payment date. No retail licensee shall be placed in default if the distributor, microbusiness, cooperative, ROD, or ROND has issued an account credit to the licensee, which after application to all debts owed by the retail dispensary licensee is equal to or greater than the amount of the default. Any such retail dispensary receiving a notice of default shall not thereafter purchase cannabis product except for cash until such time as the office determines that their name shall not be published on the delinquent list. So there you go, there's the delinquent list, as provided in subsection D of this section, or until such time as the office permits sales or deliveries to them as provided in subdivision G of this section. Each such distributor, microbusiness, cooperative, ROD, or ROND is hereby required to file with the office on or before each notification date copies of the notices sent by them to all delinquent retail dispensary licensees as required in the subdivision, and in addition, if the office shall so require, a written list setting forth the names and addresses of all such delinquent licensees. The office, in its discretion, may extend for a period not exceeding 3 days the date for giving written notice of default to delinquent retail dispensaries, and extend for 3 days the date for filing with the office the copies of notices sent to such licensees and or the written list of delinquent retail dispensary licensees as required in the subdivision. The office, in its discretion, may limit the documents to be filed to those relating to the licensees who are to be added or deleted from the default list, and direct that distributors, microbusinesses, cooperatives, RODs, or RONDs maintain copies of all other documents required under this section for future inspection by the office. The office shall, as soon as practicable after each notification date, compile and publish and furnish each distributor, microbusiness, cooperative, ROD, or ROND licensed under this chapter a list to be designated on the delinquent list containing the names, addresses of all retail dispensary licensees who have been reported by distributors, microbusiness, cooperatives, RODs, or RONDs pursuant to the provisions of this section as having failed to make payment as required by this section for cannabis products sold or delivered to them, and no such distributors, microbusinesses, cooperatives, RODs, or RONDs, on or after the 5th day after the receipt of such delinquent list, shall knowingly, willfully, or intentionally sell or deliver any cannabis to any such licensee whose name appears on such list, except for cash, until such time as the name of such licensee is removed therefrom, except as herein permitted. The receipt of a delinquent list by a distributor, microbusiness, cooperative, ROD, or ROND shall constitute knowledge of the names of the retail dispensary licensees who have failed to make payment for cannabis as required by this section. The failure of any distributor, microbusiness, cooperative, ROD, or ROND to comply with the foregoing provisions of this section may, at the discretion of the office, subject the license of such distributor, microbusiness, cooperative, ROD, or ROND to suspension for not more than 5 days for the first offense and not more than 30 days for a subsequent offense. The office may publish the delinquent list on its website, provided, however, that full access shall be restricted to those distributors, microbusiness, cooperatives, RODs, or RONDs licensed under this chapter, and access to their specific status shall be provided to retail dispensaries licensed under this chapter. Such publication shall be considered receipt thereof by all distributors, microbusinesses, cooperatives, RODs, or RONDs. Hopefully, if OCM goes the website route, they actually provide updated notice, because as of right now, they change documents left and right, and it's on you to go out and figure out if something has changed. That would be absolutely horrible, because they're saying it's constructive notice, meaning, hey, we put it out there, whether you read it or not our problem. So hopefully if they go with the website route, they are sending notice saying we've updated the list, here's a link.
Definitely a mouthful, and definitely interesting to see, like, you as someone who's licensed to distribute could lose you could have your license ability the first days, no more than 5 days of on hold, but then like second offense could be up to 30 days, so it's kind of like, they're doubling down there to make sure, okay, there's prohibition, and if you breach that, it's then going to impact your business for not playing by the rules or supporting that.
And yeah, I mean, because it all goes back to undue influence. If distributors could sell to those dispensaries, or were selling to those dispensaries on credit with no repercussions, that's undue influence, because now those dispensaries are probably going to buy those brands from those distributors, so on and so forth. So this is all kind of tying together this undue influence thing. Okay. In the event that any dispute shall exist between any distributor, microbusiness, cooperative, ROD, or ROND, and a retail dispensary licensee to whom they shall have sold cannabis products, either as to the fact of payment, or as to the amount due for such cannabis products, or as to the quantity of cannabis products sold or delivered, which dispute cannot be resolved between them, the office is hereby authorized to receive statements from each of the parties to such dispute as to the facts and circumstances thereof, and to determine whether or not a retail dispensary licensee is delinquent and should be included on the appropriate delinquent list.
So another reason for everyone involved to, make sure you're capturing your data, you're documenting everything, every step of the way, because if this comes down to, like he said, she said, it's the data, like the recordings and the evidence that talk. So really important to note. Literally,
like 99% of the stuff that I deal with in law is because something wasn't put in writing, or put in writing correctly. I mean, generally, if you have a signed and written document, that's it. That's the best evidence. There's your agreement. If you stray from that, you're probably gonna have problems at some point. Okay. The office, in the case of a retail dispensary licensee who has made payment for cannabis products, or on good cause shown to do it, may permit sales or deliveries to any retail dispensary licensee who has received notice of default, or who is named on any delinquent list on terms other than for cash, but within the limitations of this section, prior to the publication of the next appropriate delinquent list. The board may impose any penalty or condition otherwise authorized by the section in the case of any such retail dispensary licensee who fails or refuses to liquidate and pay unpaid balance becoming due under this subdivision. Nothing here contained shall be construed to require any cultivator, processor, distributor, microbusiness, cooperative, ROD, or ROND to extend credit to any retail dispensary licensee, nor to restrain any distributor, microbusiness, cooperative, ROD, or ROND from seeking to enforce by legal action or otherwise payment for any sum or sums of money due or alleged to be due to any distributor, microbusiness, cooperative, ROD, or ROND for cannabis sold or delivered to any such retail dispensary licensee. The office is hereby authorized to do such acts, prescribe such forms, and make such orders as it may deem necessary or proper to fully effectuate the provisions of this section, including but not limited to the changing of any date on which any act or function pursuant to this section is to be performed by any licensee or by the office. The board may revoke, cancel, or suspend any license pursuant to this chapter 4, actions in violation of any of the provisions of this section, for making a false statement in any disclosures filed pursuant to this section, or for failing or refusing in any manner to comply with any of the provisions of this section.
Boom. So
Oh, go ahead.
no, there's a lot in there. I mean, and it's relatively straightforward. But again, it's like that was a pretty dense section to kind of reiterate the, how serious they're approaching these things. And it's not just on the person who's defaulting, but on anyone who's participating in the economy here. So just be mindful that even if you're not someone who's on the air quote default list or doing anything technically wrong, if you're not mindful of who you're engaging with, you can get on the naughty list, or however you want to put it.
Mm-hmm.
All right, so 124.3 goods and services agreements. Exempt agreements. The following agreements shall not be presumed to create undue influence between licensees, apparent or actual conflicts of interest, or availing interest in the license by non-licensee or person who is not a true party of interest in such license. A person providing may provide such agreements across licenses. General goods and service providers. Exempt goods and service agreements may include, but are not limited to, accounting, record keeping, non-cannabis material and goods from unlicensed persons, office supplies, leasing equipment, architect services, construction, heating, ventilating, and air conditioning, refrigerating, plumbing, cleaning, janitorial, lighting, security, legal services, government relations, registered lobbyist, and license application preparation. 2, landlords. A person may be a landlord to licensees across multiple licenses. If the landlord becomes a true party of interest in a license, they're subject to the prohibitions of true party of interest of that license type.
So a good example of that would be, because I think landlords can take up to 10% of revenues. And they're not a true party of interest as long as they stay below that threshold, and they can cross the tier. So you could be a landlord to a cultivator and a retailer, but as soon as you trip that TPI, you have to pick a tier, and you can be a TPI and unlimited retail licenses. So your business model as a landlord could hypothetically be, I rent to dispensaries, and I require 15% of revenue. And that could be your business model. And you could do that unlimited times, assuming people want to rent from you. But you could never cross the tier back to, I want to rent to a processor or something like that.
All right, 3, financiers and financial institutions. A person may be a financier to financial institutions across multiple licenses. If the financier or financial institution becomes a true party of interest in a license, they're subject to the prohibitions of true party of interest of that license type. Principal repayment shall be excluded from any calculation of fees paid to a financier or financial institution in a calendar year.
We have a question from Jeff, but I think let's wait until we get to through this non-exempt agreements, because this will shed some light on it, I think, and then we can discuss it a little further.
Yeah, great. And it also goes down to contracts, contracted labor, which I think may be the following section as well.
Mm-hmm.
So non-exempt agreements. Non-exempt agreements include, but are not limited to, agreements for the provision of consulting, advisory, or strategic services related to the licensed activities. That's the big thing right there. So any person providing non-exempt goods and service agreements that has not been based on a flat fee, including but not limited to agreements based on the business performances, revenues, royalties, or profits, shall be prohibited from having any goods or service agreement with licenses in a separate licensing tier. Just rereading that in my mind. Okay. So C, management service agreement. Under no circumstance shall a person operate managed service agreements with licenses across licensing tiers, regardless of their status of true party of interest. 2, a person providing management service agreements not based on a flat fee, including but not limited to agreements based on business performance, revenue, royalty, or profit, shall be a true party of interest in the licensee receiving the services. Management service agreements shall state that the service provider, its owners, principals, and staff directly or indirectly involved in professional services or the consulting on behalf of the cannabis business are supervised and compensated in such operations entirely by the licensee. Just highlighting that. And then 4, a management service agreement shall state that the licensee and the management service provider shall adhere to the licensee's labor peace agreement and are jointly liable for any workforce related violations and services. All management service agreements shall retain the licensee's right to audit or use third party to audit the management service provider's records relating to its performance under this agreement. Stacking agreements. Where a person has multiple goods and service agreements with a licensee, the value of the payments made under such agreements shall be combined, and the combined agreement shall be held to the strictest prohibitions of each of those individual agreements. A person providing goods and services under the section shall be a true party of interest to a licensee to which it's providing such service if, over the course of a calendar year, they receive the right to or actual payment from the licensee exceeding the greatest of 10% of a licensee's gross revenue, 50% of a licensee's net profits, and $100,000, or if such person qualifies as a true party of interest by any other means in this part. Here. And then where a goods and service provider violates the financial interest in controlling conduct prohibitions set forth in this part, the office may terminate that party's interest in the license and recommend civil penalty. So that's I feel like that's the first time I've seen that language where the office may terminate a true party of interest, just being that explicit, which is interesting.
Yeah, I'm also kind of interested to see how they can, assuming that, the good and service provider is not a licensed entity, what authority they have to impose a civil penalty. I think that's interesting. But so as we can see, we sort of kind of answered Jeff's questions in there. So how does this agreement section affect, for example, processor's ability to provide a harvest crew for a small cultivator to bring in a fresh frozen harvest? So as we'll see, I think in 124.5, so the section after this, you can't contract for licensed services unless you're a licensee because they don't want you doing license. So a licensed processor could have a contract to do some service for a cultivator, but they would have to charge a flat fee because if they don't, they're going to be a true party of interest. And if that flat fee exceeds the greater of 10% of revenue, 50% of net profits, or $100,000, they will be a true party of interest. So basically, the only way you can really do it would be a flat fee and have contract limitations that say we will not exceed those numbers. Except here's one of the problems. You won't know. So they measured on a calendar year. You wouldn't necessarily know what 10% of gross revenues are or 50% of net profits are until the end of the year. Let's say you got paid January 1st, and then there's the entire year, and that payment was for services rendered the year before, and then there was a downturn. What happens in that situation where basically 12 months later, 11 months and 27 days later, your you found out that it's violates those thresholds. Do you give the money back? Is there kind of a mulligan of, we didn't know? Like, it was in good faith, but they had a downturn. Those are things to be kind of figured out. We don't know yet.
Totally.
And Jeff, your other question, across licensing tiers, yeah, I assume that it's the production and retail tiers, not canopy tiers.
Yep. All right.
Jeff has one more question. And if we charge no fee at all, would that be valued at some amount? Yes, and potentially undue influence. So you got to watch out there.
It's that kind of like gifting of whatever, a service, etc. Yeah, it's a great question. Now, could you bundle it into your, if let's just say you're a processor, could you bundle that service into the cost of, let's just say, your extraction or your tolling? You know, like there may be ways to like kind of break it down and kind of include it in the general statement you're making. But
remember, they can aggregate everything, so they're still going to look at everything you're doing and make sure that you're not tripping any of those thresholds or TPI issues.
Let's be clear, like, let's say you run the harvest, then you run the manufacturing, and then you distribute this group's product, and you're collecting percentages or value along the way. Like, they could aggregate the entire value you offer to that particular client, let's say, to determine what the true value is there. So again, let's just say the service, and then let's just say that client has a downturn, and the services and the value you brought to the table ends up being 50% of their profit that year, just because they shit hit the fan on their second harvest or whatever it is. So I think that's an important thing to note. Of like, again, it could easily become something that compounds into something more than you want. Now, that being said, like, if a farm is partnered with a processor and the processor is offering services for their farm and their brand and then distributes for them, that farm and brand will be a true party of interest in that processor, if I'm not mistaken, just innately.
And the big takeaway is that OCM really doesn't like management services agreements. They don't want unlicensed people effectively renting licenses, which is very common in other states. And this is their whole, provision against that, is basically, if you want to do licensed activities, then get a license.
So 124.4, agreements creating financial or controlling interest. So under any circumstance, the office reserves the right to review any agreements between a licensee and a third party. A third party will be deemed a true party of interest with financial controlling interest in a license where such agreement, 1, compels the licensee to promise not to purchase cannabis products, or other product or material from, or sell cannabis products, or other goods, services, or materials to specifically identified applicants. So is that just basically saying like non-compete? So if someone will be a true party of interest or have controlling interest, or if they're able to say you can't sell to this group, for example.
Yeah, or I'll sell to you, I'll sell you my brand, but you're forbidden from buying anybody else's brand. That's a no-go. And I just want to point out too, that first sentence is really important. Any agreement between a licensee and a third party. So, we all kind of say, is OCM really going to review every agreement? No. But just like what happens with like DOL investigations and stuff like that, it's going to be, there was an agreement and somebody gets, upset with the other party and blows them in. And then it triggers OCM to request all those documents. So don't think that you're going to like hide something in a document and rely on the fact that OCM is never going to review every single document. They probably won't. But if something goes wrong, that's when it comes up.
Yep. And I will also say too that the prohibition, like that part 1, it doesn't say that it's not allowed, but what it says is if there's an agreement between a third party and a licensee, and that third party mandates not selling to this or doing that, you must do this or you can't do that. they immediately become a true party of interest or a controlling interest, which is just important to note. Also, just to kind of follow up on that previous stuff we've been talking about, Jeff asked, like, is there anything tricky here for the co-op model, i.e. requiring some percentage of harvest to move through the cooperative, being able to provide services to members, or do we need to ask for cooperative exceptions? I do think that is a clarification required here. As we talked on the last call, like there's a lot of things that aren't really clear on what a cooperative can or can't do, or how true party of interest is experienced or expressed through a cooperative model. So definitely a good question, and I'd say absolutely requires at least clarification here.
Zach, we also have a question in the Q&A.
Cool.
Says, does this also apply, meaning you can't have a processor manufacturer products for your brand without having a license yourself? So a brand, as we discussed at some point, I can't remember when, a brand has to get what they're basically calling a processor license now. That's like the lowest tier, is what we think, or they're going to be a TPI in the processor's license. So it's still kind of getting worked out exactly what that is, but some way or somehow, like you're going to be connected either by your own license or to the license that is effectively white labeling for you.
Yep. And then just to kind of circle back, D King says, on the flip side of this point, can retailers be permitted to have exclusive products, i.e. only organic or only outdoor, or even exclusive to a few specific growers? What is clear is there cannot be exclusivity across tiers, but a retailer could, I think, and correct me if I'm wrong, a retailer can structure their business model any way they want to have the inclusivity to hit the target audience, et cetera. But there can't be a mandate from a producer to a retailer. That would be illegal.
Yeah, a retailer can sell whatever they want, but they can't be limited in what they want to sell.
Yep. Yeah. And yes. And Lee, that's what we're hearing right now, that like there will be a brand processor license for brands to ensure everyone who's participating in this economy is registered. Though the final name and expression of that is to be determined. Yeah,
because it is beyond confusing to refer to what is effectively a brand license as a processing license.
Yeah. All right. So this is where you'll, again, crossing the threshold into true party of interest and or control. Impose penalty upon a licensee for non-compliance with the agreement that requires surrender of personal assets of the licensee owners or principals. So if there's agreements there between third party and licensees, that third party, under those terms is automatically a controlling influence or a true party of interest. 3 is not bargained for between the parties in an arm's length transaction. But can you explain that a little bit, Jason?
So arm's length transaction is two unrelated parties. So I think what they're trying to say there is basically if you had like friendly terms that were not market rate, then OCM is going to look at that unlicensed person as a TPI based solely on the fact that you don't have an arm's length transaction.
Yep. Okay, cool. 4 does not include the ability for either party to terminate the agreement with due notice. Or 5 creates an employee-employer relationship under the New York State labor law between the licensee and non-licensed person based on the agreement services to be performed under said agreement. Okay, so contracting limitations. This is also an interesting section. An adult use is kind of like, this comes full circle on like licensed performance versus non-licensed performance of specific services. Adult use licensees are prohibited from contracting or subcontracting with a person or entity performing any function or activity directly involved in licensed activities authorized for that license type, including but not limited to cultivating, processing, manufacturing, distributing, or selling cannabis products. So basically it's saying like, this is an interesting thing to note here. That's like person or entity performing, like this could be interpreted loosely saying any. Like it doesn't say like, if I read this, is it incorrect that you could say, okay, well, adult use licensee are prohibiting from contracting subcontracting with a person or entity performing any function. Like, could that also go to other license holders? Like, they don't want you. I could read this saying they don't want you to contract anything that's specifically outlined in your production process. So if you're a cultivator, which is trimming, is everything from seed, like your nursery stock, all the way to trimming, technically you couldn't hire, I could read this saying you can't contract anyone else, any person or entity, even if it's licensed.
That's a fair read. I think you should probably add that to the spreadsheet. Because that's an important distinction that needs clarity. Because I could see that too. Like, I could see them prohibiting what you just said, because that effectively allows you to increase your canopy tier. I mean, it's still overall the same amount in the state, but you know, if you have one grow that's 10,000 square feet and you're managing another grow for somebody else that's 10,000 square feet, you really have a 20,000 square foot grow.
And just this goes back to the previous conversation we had, and DK says certainly harvesting and curing are processing. It's technically not. Harvesting and curing is explicitly cultivation, including trimming. But I think trimming can overlap into processing, and that's where, again, like, clarification is needed here. And like, definitely comment. So I would argue that, like, you know, there's also a lot of folks too who are like, oh yeah, I want to start a trim business, or I want to offer services. It's like, if you cannot offer services, one, as an unlicensed person, and two, it's clear here that maybe no one can offer core business functions to a particular license type. And that's really important to note.
Yeah, basically, they don't want you 1099ing people, even if it's innocent. Like, I'm not saying stacking the licenses or whatever, but as Zach kind of said, you know, we want to just bring in a trim team because we don't want to hire all these employees for just this one process that's going to last a couple of weeks or whatever. You can't just 1099 a trim team like that. That A 124.5A absolutely prohibits that.
Yeah, exactly. And that's where, again, like, even just Jeff's comment saying, like, there is definitely a disconnect between the lip service of wanting to support small producers and not allowing contract labor for peak times, planting, harvest, trimming. And again, it's like, so yeah, you have to then, like, put everybody on your books and then pay unemployment. If, let's just say you're a small outdoor farmer, and it's no matter what, it's so much work to get the job done at these key points of, like, planting, the caretaking pushes, and the harvest push. And so, like, if you can't hire outside help, then everyone needs to be brought on into your books, and that has a real cost to it. Mm-hmm. Now, I'm like, I understand, like, that they want to build businesses and they want to build jobs in this market, but prohibiting, like, shared services is definitely a concerning limitation at the very least. So if I have a processing, D King asks, if I have a processing license for mechanical extractions, so solvents here, an employee or contractor I hire must hold a processing license as well. I mean,
if they're an employee of yours, they would be under your license.
And if you contract, it seems that, like, I mean, just looking here, like, you couldn't, I'm reading 124.5A, that you couldn't contract someone to do any business, like, core business functionality that is explicit to your license. Which is just really, again, it's tricky if you were thinking about bringing someone on to offer a third-party service. Now, here we've had a conversation, like, what about hiring an offsite, or a, like, a CFO or a CPA, someone who plays a role, like contracting kind of like a role that doesn't necessarily need to be plant touching versus plant touching processes. Like, where is the division here of, like, who you can contract out versus not? When, like, CFO and, like, financial stuff is core to the business, but it's not necessarily a license activity authorized for that license type. And that's the explicit language we need to be mindful there. Yeah, and a worker-owned cooperative could provide many full-time livelihoods if allowed to service many producers. I definitely agree with that. All right, so B, adult use licensee may contract with a person or entity performing a function or activity ancillary to the licensee's license activities, including but not limited to accounting, record keeping, architectural services, construction, heating, ventilating, air conditioning, refrigeration, plumbing, cleaning, and janitorial, lighting, security, and legal services. All right, so, and then 124.6, severability. If any provision in this title or its application to any particular person or circumstance is held to be invalid, the remainder of this title and its application to other persons and circumstances shall not be affected thereby. So that's a big section right there. Like, I think it's just, there's a lot we can unpack that last point. Like, a lot of folks are concerned about, the trimming services, the harvest crew, all of this stuff. Like, it's commonplace in other places specifically for outdoor production in California. Like, this is where I was turned on to this, where you would hire a crew that maybe is connected to the processor. Let's just say they are, in this case, for sake of ease, they're connected to a processor that will come cut the flower, the fresh frozen material out of your farm, put it in a refrigerated unit, and then bring it to their their processing facility. So kind of closing that gap by offering a service that really on a level ensures that the processor is getting a product that they want under the conditions that they want it. So just again, another example that's curious to note and curious to understand how that will actually impact bottom line and opportunity. All right, so 125, general operating requirements and prohibitions. Jason, shall we just keep plugging away here?
Yeah, might as well. This is some of this stuff we're going to see comes into play during the application process, like the environmental plan is one of the requirements. So yeah, the important section, dive in, and it's going to be pretty dense because this is effectively the last section, which is probably going to take up, about 70 pages, 80 pages, something like that.
Yep. And just Perry asks, is anyone planning here on submitting comments regarding what is covered today? If so, what organizations? Let's just be clear, individuals can absolutely comment, as well as organizations. A lot of our dialogue is I bring up things personally that I will comment on personally, where we're connected to different organizations where other key points may have value and be, commented on through like an association, for example. So there's a lot of different organizations out there, from like industry associations to consumer groups to et cetera. So like there's no prohibition on who can make a comment here. So know that where I'm taking notes and I'm adding little notes and stickers, I definitely intend to make comments and bring to further discussion elsewhere.
And when making comments, my suggestion is to identify the problem and propose a solution, and maybe even throw in an explanation of why it's a problem to begin with. Because if you can kind of tie that loop for OCM, it's going to be they're going to react a lot better to it than this is wrong. End of story. Like that, they're just going to throw that away basically, because that doesn't give them anything. Yep.
All right, so part 125 covers a lot, operating environmental plans, security and storage, employee requirements, responsible vendor training, work health and safety standards, sanitary facilities, inventory and tracking, quarantine, remediation, recalls, transportation, management and of cannabis and other waste, inspections and audits, record keeping in general, processing samples for internal quality control, and severability. So there is a lot we're about to unpack here. Jason, can you take the lead on this section?
Yep. Okay. 125.1, site operating and environmental plans. Site plan. A licensee shall document, implement, and maintain a site plan, which shall be submitted to the office in a manner and format determined by the office, consisting of the following information: activities performed in each area of the licensed premises, details of all parcels or all parcel boundaries, including but not limited to physical boundaries, road and water crossings of the property, sanitary facilities as applicable, perimeter dimensions of the property and any facilities on premises where licensed activities are taking place or cannabis products are being stored, entrances and exits to both the property and premises. Licensees authorized for cultivation shall also include in its site plan the following additional information: cultivation area, including aggregate canopy square footage if the areas are not non-contiguous. All unique areas separated by identifiable boundaries shall be clearly described and labeled in the premises diagram. Plant bed diagrams noting canopy square footage shall be kept up to date with the office. Any material change to the site plan shall receive office approval. Areas outside of the cultivation area for immature plants, seedlings, clones, and mother plants only, if applicable.
This is actually really important to note. There's a huge, like I'm seeing a lot of questions from folks saying like, is canopy flowering canopy? How do we define canopy? And what's being recorded here. And just here, it makes it clear that areas outside the cultivation area for immature cannabis plants, seedling, clones, and mother plants only. So that sounds like a nursery. That sounds like kind of a staging area where canopy is the place where production is set and will continue to go. So now the question is, like, if you have immature cannabis plants in zones that are, your canopy, or like, is any plant that's registered in your canopy, even if it's immature, considered, a canopy contributor? Like, is there a threshold between immature and mature here that crosses when it comes to canopy?
The way I would read this is, if you designate this is my flowering canopy area, a plant bed that's 10 by 10 or whatever, and you put half of that with immature cannabis plants, which are non-vegetative, non-flowering, and less than, I think it's 2 feet tall, but it might be a foot tall. I forget which definition they use. I think that still probably counts for OCM's purposes as flowering canopy, unless you change that designation, because all OCM knows is what you gave them. So if you suddenly start growing canopy, flowering canopy somewhere else, because you're only using half the flowering canopy space that you designated, and you get inspected, I think they're going to cite you on that because you didn't update them.
Yeah, and that's a good question too. D King says, is a plant mature at the first sign of flower? These are all things that need to get clarified. And again, it's even so kind of ambiguous that, like, a nursery, immature plants in a nursery is like up to 2 feet tall, where immature plant in a production system is 1 foot tall. Like, there's inconsistencies here that really need to be kind of drawn out. And this is where, like, hey, OCM, we see 2 different definitions at least of immature or mature plant. Can you please define exactly what that looks like for us? That's a comment that could be made.
And just to reference back to the definitions, canopy or cultivation canopy means an area to be calculated in square feet and measured using clearly identifiable boundaries that will contain non-immature cannabis, which shall be vegetative or flowering plants, excluding seedlings or small clones. So that's what OCM has said canopy, or canopy space, means.
Yeah, agreed, Lee. Okay, so continue.
So, all right, pesticide and agricultural storage area, drying area, harvest storage area, a list and description of any lighting used for cannabis cultivation with wattage and photosynthetic photon efficiency and placement, and other activities or licensed areas. If applicable, a cultivator shall keep all areas used for adult use cannabis operations, including any growing, harvesting, drying, or storage areas, separate and distinct from any areas designated for hemp cultivation authorized by the Department of Agriculture and Markets. And licensees authorized for cultivation and processing shall also include in its site plan designated areas for bulk packaging, composting if on site, and secure cannabis waste, not including composting areas, and any other designated areas as determined by the office. Operating plan. A licensee shall document, implement, and maintain an operating plan, which shall be submitted to the office in a manner and format determined by the office and made available to the office upon immediate request. The operating plan shall consist of the following information: a security and employee training and safety plan that includes risk mitigation and accident prevention plans resulting from a risk assessment of all licensed activities, including an up-to-date list of authorized employees who have access to any surveillance rooms, an overview of all activities the licensee is authorized to engage in as applicable to the license type, including but not limited to cultivation, processing, distribution, transportation, retail, sale, and delivery. A quality assurance plan that establishes criteria to detect, identity, identify, prevent and track cannabis and cannabis product contamination incidents, a cannabis recall plan that includes an annual mock recall test, a cannabis testing plan as applicable to the licensee that includes sampling and laboratory testing of cannabis or cannabis products, which is based on risks associated with materials or organisms normally present during cultivation or processing of cannabis, and meets the sampling, transportation, and laboratory testing requirements as set forth in Part 130 of this title. Licensees authorized for cultivation shall include in their operating plan the following additional information: a soil or grow medium preparation plan, a pest management and control plan that shall meet the following minimum requirements. Be based on integrated pest management (IPM) principles that are adequate for the facility type and size. Include details on prevention, observation, and interventional steps and physical, mechanical, biological, and chemical methods utilized that are consistent. Demonstrate conformance with the list of authorized and prohibited pesticides and materials as determined by the office, and use only those pesticides approved by the New York State Department of Environmental Conservation for use on cannabis, and emergency spill management procedure. Licensees authorized for processing shall include in their operating plan the following additional information: if applicable, a description of all the extraction methods and chemical solvents or other materials used in the extraction method and the equipment used to perform the extraction, and emergency spill management procedures. Licensees authorized for retail dispensary activities shall include in their operating plan the following additional information: the current employee in charge and standard operating procedures for responsibilities outlined in 123.10C2 of this title. Documentation demonstrating the retail dispensaries in compliance with section 123.10F1 of this title. Procedures to remain compliant with applicable local ordinances such as those pertaining to odor, noise, outdoor lines, and max capacity. And licensee's delivery plan, if applicable, and any other information as determined by the office. Energy and environmental plan. This is important because this is one of the ones that is specifically noted that you have to submit with the application. It does not seem that it's going to be one of those provisional time periods after you get granted a provisional license. You have to give information to the office. This one seems to have to go in with your application, so it's important. Energy and environmental plan. Licensees shall document, implement, and maintain an energy and environmental plan explaining operational process for stability, sustainability, and tracking such processes in a manner and form determined by the office, which shall include, but is not limited to, actions to reduce or eliminate the applicant or licensee's use of single-use plastics in accordance with the retail packaging sustainability program outlined in Part 128 of this title. Actions that will be taken to minimize both the use and disposal of chemicals that are considered hazardous waste when disposed. Actions that will be taken to use compost or other recycled organics as a component of growing media. Areas to reduce the applicant or licensee's carbon footprint, including but not limited to a sustainable energy use and conservation plan that addresses the sourcing and use of energy to include for new buildings or existing buildings that are going through expansions or renovation. Cultivators shall be subject to minimum lighting system efficiencies, building energy efficiencies, including ERV, energy, heat, recovery, ventilation, building and equipment standards as determined by the office, the premises proposed energy impact and energy efficiency goals, including timelines and benchmarks in accordance with those put forth in guidance, as well as how a licensee will engage with energy efficiency programs. Practices to limit energy usage or electrical usage or improve building insulation, and opportunities for renewable energy generation, including, where applicable, submission of site plans showing where energy generators could be placed on the premises and an explanation of why the identified opportunities were not pursued. Submit an annual energy report, which shall include energy benchmarking in a manner required by the office. All planned lighting and the energy impact of the planned lighting to meet all standards set forth by the board, including but not limited to lighting standards for cultivation areas and all indoor and mixed light facilities. Horticultural lighting used in a facility shall be listed on the current Design Lights Consortium Solid State Horticultural Lighting Qualified Products List, Horticultural QPL, or other similar list approved by the office as of the date of the license application. Existing lighting. Existing horticultural lighting equipment can be used if already in place at the time of conditional licensure. Technical details, wattage input, photosynthetic photon efficiency related to existing equipment shall be submitted to the office within 30 days of licensure. For equipment that does not meet the minimum requirement for PPE, 1.9 micromoles per joule, a documented transition plan to more efficient lighting equipment shall be in place by the conclusion of the first year of production for the licensee. Applicants shall have a plan to transition to a lower energy footprint system, which may include but not be limited to a PPE of no less than 1.9 micromoles per joule, oriented toward a net zero emissions target after the conditional licensing period is over. The plan can include on-site renewable energy production, more efficient lighting equipment, carbon offsets as approved by the office, and demonstrable carbon sequestration practices approved by the office. Cultivators in indoor and mixed light tiers 1 and 2 shall be subject to a minimum lighting PPE of 1.9 micromoles per joule. Cultivators in indoor and mixed lighting tiers 3 and larger shall be subject to a minimum lighting PPE of 2.2 micromoles per joule. A facility seeking to use horticultural lighting not included on the horticultural QPL or other similar list approved by the office shall seek a waiver pursuant to a third-party certification of the energy efficiency features of the proposed lighting. Placement of interval meters within every grow room and at least one for the operating space to capture entire facility footprint. Plans for incorporating staggered peaks into lighting schedules to spread out electrical demand. Participation in load shedding or other demand response programs like behind the meter storage, and proof that the licensee has contacted their local utility to confirm expected energy draw and impacts to local grid, and environmental control and odor mitigation plans that meet all standards set forth by the office, including but not limited to dehumidification equipment shall be one of the following: standalone dehumidifiers that have a minimum integrated energy factor of 1.77, whatever units that is, for production, liters per kilowatt hour. I don't know. For product case volumes of 8 cubic feet or less, and minimum integrated energy factor of 2.41 units for product case volumes greater than 0.8 or 8.0 cubic feet. Integrated HVAC systems with on-site heat recovery designed to fulfill at least 75% of the annual energy for dehumidification reheat. Chilled water system with on-site heat recovery designed to fulfill at least 75% of the annual energy for dehumidification reheat, or solid or liquid desiccant dehumidification systems for system designs that require dew point of 50% or 50 degrees or less. A refrigerant emission reduction plan, including either plans to utilize HVAC and refrigeration equipment with ultra-low global warming potential or natural refrigerants, or a plan for managing refrigerant leaks and disposal. Indoor cultivation facilities, with the exception of micro business and tier 1 and tier 2 cultivation licensees, are required to utilize technologies for heating and cooling that do not involve on-site combustion of fuel. Acceptable alternatives to fossil fuel-based systems include, but are not limited to, ground source geothermal systems or air heat pump systems. An HVAC and odor inspection and maintenance plan shall include, but not be limited to, description of manufacturer's requirements for inspection and maintenance of mitigation systems, and description of how licensees will ensure proper operation and energy efficiency operations, including but not limited to practices to limit or improve odor control and air filtration. Zach, it is now 1:15. Shall we pause?
Yeah, I think
Because
it's definitely this environmental plan keeps on going. So let's definitely take a pause. I'll stop my screen share. Obviously, again, this is where we're going to get into some more specifics. It's definitely going to get complicated. It's definitely robust, but you can deduce a lot of this in this planning stage of pre-licensing. You can deduce a lot from understanding this section as to what the expectations are going to be of your business. It can help you develop your SOPs, as well as like begin to price out actual costs of doing business and preparation. So there's a lot here for sure.
Yeah, I mean, really think about, like, the fact that if you're not a micro tier 1 or tier 2, you can't use fossil fuels, like natural gas, at least upstate, is like the most common form. And, geothermal, while a great energy source, is very expensive to install. I mean, it's, 30 to 50,000 for like a residential house. So, just think about what that's going to add in terms of your cost to like your business plan when you're trying to kind of projecting out all these numbers.
Totally. Unless anyone has any really burning questions, I'll give a moment here, but we'll begin to wrap things up. Just really appreciate everyone engaging in the chat here. Definitely really helpful to help us kind of see places where we may be blind to or not commenting on. So really, really great there. Jeff asked, not applied to mixed light though. That's a great question. Did it explicitly say indoor or did it just say tier 1, tier 2?
Indoor cultivation facilities.
There's definitely some really there's going to be strong limitations and environmental controls on mixed light as well, just to be clear. Jason, can you repeat what you said about the fossil fuel? Just it's anything above tier 3 indoor cultivation.
It's indoor cultivation tier 3 and above. They're required to utilize technologies for heating and cooling that do not involve on-site combustion of fossil fuel. So, natural gas or anything like that, I don't think it's going to work. You're going to need to use geothermal, air source heat pumps, which for us, air source heat pumps are not super efficient because it can get so cold.
Yep.
And so that requires, a potential backup of electrical resistance heating, which is very inefficient and very expensive. So, you really got to think about these environmental plans if you're doing tier 3 or above indoor grows.
Yep. All right, everyone. Well, thank you so much. We'll be here next week, Tuesday, Thursday, noon until 1:15, and I'll be darned if we don't complete this read through next week. So we're cruising along. Yes, thank you so much for your time. Thank you so much for CANY for helping provide this platform, as well as the Rochester Public Library for your collaboration. And yeah, just everyone for being on this call, making the time, learning, studying, as well as those who are watching this recording. So have a great weekend, be safe, and we'll see you soon.